I have been with Hinshaw & Culbertson now for 18 years, and I have been practicing with an equine law focus for approximately 15 years. I am an equestrian myself. I ride in the discipline of 3-day eventing, which allows me to essentially be boots on the ground for my clients. I understand what they face as far as liability risk, and most importantly, I'm trying to encourage the continuation of the sport by helping those in the sport, both amateurs and professionals, to minimize the liability risk exposure so that we can continue to encourage equine activities. This presentation is CLE for our practicing lawyers, but I also want to encourage those who either not only have clients engaged in equine activities, but those of you that are in fact firsthand engaged in equine activities to take away from this ways to continue to do what you're doing in the equine industry, just do it a bit better. So how do we encourage equine activities in an environment where it's inherently dangerous? Well, the legislatures decided that it would be helpful to delineate the responsibilities of the equine activities onto the participants. So in those states where there's an equine activity liability statute, the assumption of risk is explicitly provided, that it is on the participant in the equine activity to assume the inherent risks of that equine activity. It is on the participant in the equine activity to assume the inherent risks of that equine activity. What does the state law provide? It's important to know what is stated in that statute because it will dictate whether or not there is liability coverage in a particular situation. So it's important to know if somebody gets hurt, are they defined as a participant engaged in an equine activity injured as a result of an inherent risk of that equine activity? And we're going to break down each one of those elements on further slides, but I wanted you to understand that whether or not you have liability protection in any particular situation is if the person or the circumstance fit within those definitions provided by the applicable state law. What the statute also provides is exceptions to liability protections. So if you are an attorney representing your client who's being sued, and you've read the definition, and it's your opinion that your client did everything correctly under the statute to be afforded the liability protection, it's equally important to understand what are those exceptions to the liability protections. Where has the state taken away the liability protection that it otherwise afforded? Each state has a warning sign posting requirement. In those states, the warning sign posting is required or there's no liability protection. In some states, a warning sign posting is not required. So it's important to know if you as an attorney are representing a client and you're going to be relying on the liability protections afforded by your state statute, that your client complied with the statute by posting the required warning sign. States such as Florida give you the option of posting the warning sign or having that same warning language in the liability release. Well, one point of focus in this presentation towards the end is going to be using those liability releases. Well, clearly you can't comply with the state writing requirement if you don't use an actual liability release in writing. And we'll get to that important point here on in the presentation. And the final definition provided by the state law that I wanted to address is the warning language that's required to be in a contract. This is not a provision that as lawyers we can just draft because we are artful drafters. The statute will actually provide for you what language is required in your liability release to comply with the statute's warning requirement. I mentioned earlier in my presentation that the statutes do have warning sign posting requirements. Now the caveat to that is not every state has a warning sign posting requirement. So again, it's important to know wherever your client is conducting equine activities, or if you are the industry professional or even an amateur who has property with horses on it, know if your state statute requires the warning sign posting. Now I know these warning sign postings they're aesthetically pleasing, right? If you have a burgundy and green barn, you're not going to want this metal black and white sign on your barn. But I'm going to tell you what you don't want more is a lawsuit that is successful against you because you failed to post your warning sign. So you are going to post these warning signs in a clearly visible location where equine activities are taking place. And I get asked all the time, well, what if the person that's injured said they didn't see the sign? I'm going to tell you that not one of these statutes in 47 states state that the participant must have seen, read, and understood the warning sign. It doesn't say that. All the statute says is that you must post this sign in a clearly visible location where equine activities are taking place. Those signs must have the language provided by the statute. You cannot draft these signs in different words. You cannot change the verbiage in any way because you think it writes better. They must be in 1-inch black letters. Again, you have your burgundy and green facility. You cannot have your letters in burgundy and green if your state statute says 1-inch black letters. Now, I've just focused on contracts because I'm very passionate about using liability releases and other contracts to provide liability protections where the statute fails. You just heard my presentation on what the Equine Act says, what the Equine Act does not say, what is required for your client or you as the equine activity provider to have liability protections. But we also see from the example that I gave you, and I could give you many more, of where the Equine Activity Liability Act was not enough. You can reduce the risk of liability for your client by advising them that liability releases can be used to provide liability protection. They are enforceable when done right. And you as equine activity providers, you cannot benefit from the liability protections of contracts if you don't use them. Liability releases are an actual, practical, real-life way of minimizing the inherent risks of equine activities liability that we just saw you have exposure to, even under those states where a liability statute is in place. Now, I've talked a lot about liability releases, and I'm circling back to this again because it is so important. Liability releases may have a myth behind them that they're not worth the paper that they're written on. But I'm here to tell you today, and my presentation that's going to follow this one focuses on not only are they worth the paper they're written on, but they're worth so much more. They provide defenses where you may not have otherwise had a defense. So I want to point out in this slide to say first that liability releases under some of these state statutes that have an Equine Activity Liability Act are explicitly enforceable. So while you might think they're not, the statute's actually telling you that liability releases can actually be used to provide liability protections for the person providing the equine activity or the facility providing the equine activity, and can specifically provide a waiver of rights by the participant. So not only do we have an Equine Activity Liability Act that provides an express assumption of risk and defines the inherent risks of an equine activity,